started well because now Kohli is taking up now. Basically because now ultimately the purpose is to copying the original drug, either biosimilar or generics, whatever it is. But the concept of the jurisprudence have evolved in India to that extent today. There is something like quiet limit action. All the litigants who are in the courts, they are aware about this quiet limit action. Now I think Mr. Pratik will be looking into that aspect also, but I appreciate Mr. Pratik also looking into the point of that Alimbo judgment of relocation versus vis-a-vis counterclaim. I'm sure you will be touching that. Now, earlier point of time, any somebody wants to file a suit for infringement, there should have been a cause of action. But today you can go to the court and say that cause of action has not arisen, but it's going to arise in the future. That's what is exactly the quiet limit action. If you are able to demonstrate before the court to say that somebody is going to launch this product in future, he is going to create a damage to me, please stop him doing that. But precisely this is a good jurisprudence, the reason I say, because somebody if launches the product and spends some money amount on that, and later on the plaintiff goes to the court and stops the defendant, it's not in the interest of both the parties. But somebody is going to invest something in that, which is going to violate the rights of the XYZ, then that is under quiet limit action. Courts have started the granting injunctions, and fortunately, lesser known courts other than the Mumbai and Delhi, the Hyderabad also, the commercial court judges try to understand this subject. It's an evolution and the jurisprudence is being evolved now. Now I'm sure because I think Mr. Pratik also will take me as it is my personal interest, because there is something like when the counterclaim is filed, also revocation is filed, and the moment one of the most important subjects still it touches me because somebody files a counterclaim. The moment you find a counterclaim, the commercial court loses jurisdiction, matter goes to High Court. So this is the strategy being adopted by the defendants. Anyhow, and this particular point will be touching upon Mr. Pratik and Pratik.
Thank you so much, Dr. Reddy. And I'll try to be colleague as much as I can. Interestingly, before I jump on to my topic and the content which I'm going to share with you guys, I was attending a similar program besides. It was about AI. And recently in the newspaper we all read about the fight between Google Bard and ChatGPT. ChatGPT won and the share prices. So I wanted to check whether there is some content there in that news or not. I wanted to check whether ChatGPT is in fact better than the Google Bard or not. And apparently it seems that ChatGPT did better because I tried to search, because of the topic, obviously we rely upon nowadays on Google. We Google everything, we make these presentations, we try to search the content, it is at the fingertips. So on ChatGPT I searched which is the world's first medicinal patent. And it answered that Locke's patent, there was a scientist called Locke, he got a patent in 1600 which was granted by the Crown. Because at that time the Crown used to grant the patent. There was no legislation or there was no patent office in those era. So it was for stomachache. The medicine was for the stomachache and it was world's first patent which was granted for the medicine. I searched the same question on Google and it said that the American patent, Lee's patent, which was also for stomach ache and dizziness and XYZ, that is the first patent in the world. So no wonders the shares of Google dropped down. So I got my answer, which is the best AI right now in the world. So there was just a trivia thing. Now moving on to answer what Dr. Reddy has very correctly raised the question about quad-aiming actions. Yes, he is very much correct that in quad-aiming action, a plaintiff can file a suit for infringement even when the actual cause of action has not even arisen. But there is a chance, there is a possibility that the defendant is going to come up with some product or some process which will infringe my patent. What time it means? Before it has even occurred, the action has even, the infringement has even occurred, I go to the court and ask for an injunction, that is quad-aiming action. The problem what generally we face that in order to prove that the defendant is about to come up with particular infringing product or process, there has to be some evidence before the court. I cannot simply file a suit under whims and surmises saying that since X company is my competitor, so they will launch some product which I have recently launched and I have got a patent on that. So on whims and surmises I cannot file. There has to be some evidence to show that he is likely to launch it. Now what can be those evidences? Those evidences can be their website. Their website may speak that we are going to launch this particular molecule. We are in the process of launching this particular molecule. They list your patented product on their website and try to tell it to the people that they are going to come up with this product. That can be one of the evidence. One step forward now in the patent enforcement procedure, investigators are being hired who go to the premises of the defendant. They try to reason with them as a client, a prospective client. They try to gather the evidences from them, and on the basis of those evidences, nowadays the patent suits are filed and injunction is being asked from the court. One of the cases which we handled in Gujarat, it was for Novartis, and an ex parte injunction was granted. It was filed under quasi-judicial action against one local company who had listed the vildagliptin on their website, stating that they also provide the API vildagliptin. Vildagliptin is a patented molecule. So, on the basis of that advertisement on website, this suit for patent infringement was passed. The commercial court in Gujarat granted an ex parte injunction. The matter was proceeded ex parte. The plaintiff, we read the evidences, we filed out the evidences before the court. Everything was done. Surprisingly, at the end, the judgment came against the plaintiff, despite of the fact that the defendant did not even appear before the court. He did not lead any evidence before the court. The suit was rejected. The reason, surprisingly, the reason was the suit was filed for quasi-judicial action, saying that he has listed the product on the website, so is infringing my patent. The court took the view that you have just shown the apprehension that he is going to infringe. In the trial, you have not proved that he has infringed your patent, so I am rejecting yours. Interestingly, we had to go for a first appeal before the High Court, and again it was an ex parte matter, and the High Court took the view otherwise and considered the quasi-judicial action in its correct spirit, and ultimately the injunction was granted because it was a patented molecule. And the defendant was not going to suffer any harm because he did not even appear before the trial court or the High Court. So these kind of actions, quasi-judicial actions, are very tricky, crucial, and it requires like a great deal of like strategy in handling such kind of cases. There are few issues in patent litigation which, as a litigator, I think Mr. Reddy must 100%, he's a very senior advocate, he must have come across so many cases and he must have dealt it personally, and also Dr. Sehgal and Shikha. Now, there are certain issues like defendants generally what they do when we file a patent suit before the trial court, they challenge that patent on maybe a good ground, maybe a baseless ground. The strategy is just to drag the litigation. Because under the Patent Act there is a provision that once the defendant files a counterclaim or by which they challenge the validity of the patent, the suit transfers from the trial court to the High Court. Now, trial court will not have a jurisdiction. It will be the High Court who will decide the case. Unfortunately, the special IP division bench, which is there in Delhi High Court now because of the IP division rules they have formed, so there it is easy to litigate such matters because it will get expedited because they have a separate court, specialized judges who deal with IP cases in so many years. But that same scenario is not there in the rest of the country. Recently I read that Madras High Court has in fact asked the government to frame the IP division rules and form an IP division over there. So the need of the hour is that rest of the other 29 or 28 states, they need to make special IP division benches at the High Court level. This third challenge generally in patent litigation we face is proving the process patent infringement. Product patent infringement is easy to prove. Sitagliptin, vildagliptin written on the website, I file a case, get an injunction, matter. When there is a process patent infringement, how do you prove it? You don't know the process, which process defendant is using. You have probably hired an investigator, he is not able to obtain the information about the defendant, his manufacturing process. Then what do? You go to court empty-handed saying that's the same product we are making, but I think he's infringing my patent. The court will say, where is the evidence? You don't have an evidence. So generally what strategy we do in such cases is that we try to analyze the product of the defendant through some lab, try to understand that what all small markers are present in their product, which markers can also be found in your product. Because suppose certain solvents or certain raw material that are being used, it will always leave some trace in the final product, which will be the impurity. Now, if the same impurity is there in both the products, then in a way, because in process pattern infringement can be proved only through corroborative evidence, there cannot be a direct evidence. Direct evidence can only be obtained if some court commissioner or court receiver visits the premise of the defendant and will see himself what process they are using. That can be the only way. The second way is that the section itself, the Patent Act itself provides that in process pattern infringement, the plaintiff has to prove that the products are safe. Once that burden is discharged, the court asks the defendant to disclose his process. That now it is your turn, you disclose it. But nobody is Sriram or Yudhishthir to disclose very openly that no, yes, I am copying, this is my process. Even if they are copying, they will not disclose it. So the best hold mechanism would be that the DCGI, the Drug Controller General of India, CDSCO and GST authorities, they must be given some mechanism or some framework through which these evidences can be collected from those authorities, government authorities, and that can be used as an evidence in the patent infringement, especially the process patent infringement. The judicial view has also changed a lot. Earlier, the scenario was that there is a book called Terrell on Patents. I don't know, like those who are into IP litigation or those who follow patents, they must have read this book, Terrell on Patents. It's a very celebrated book on patents. It cites one judgment wherein it is written that older patents are required to be protected, new patents need no protection. Why? The reason why Terrell says that is because older patent is a tested patent. Nobody has challenged it. Even if somebody has challenged it, it has understood, it has undergone the pre-grant opposition, post-grant opposition, 5-7 oppositions were rejected. So it is a time-tested patent, so it should be protected. Now suppose we are in 2023, I am granted a patent in 2022. So going by that logic, if yesterday I got a patent, now as per that logic, then I should not get an injunction in the court of it, because it's a new patent, it is not a time-tested patent. But this view subsequently changed, the litigation landscape changed, the court started taking a prudent approach to this. And one very good judgment of Justice, I forgot the name of the judge, but Delhi High Court judge, in the Starlight matter, he took a view that in patent infringement cases, ultimately, you should grant an injunction. Very good. Just forgot the name. He held that in patent infringement matters, injunction should be granted. There are two reasons for it. One, if the defendant is not infringing the patent, suppose he takes a defense that I am not infringing it, then he should not be afraid of the injunction. Because the court will not hold him for contempt. If he is infringing the patent, and if he has got good grounds to show that this patent is invalid, prima facie, he can come to the court on the first date itself, show the evidences, and the stay can be vacated. But there is no logic for not granting an injunction to a patent, a valid patent certificate which the plaintiff is holding ultimately. Why there cannot be no reason for not granting an injunction to a patent. So we have come a long way. Much more has to be done in this area, and I think I have answered the questions of